Good morning. Good
Good morning,
morning.
Your Honor.
Can everyone hear me okay?
Good
I
morning.
can hear you, Your Honor.
Okay, very good. Okay, we're here on cause number DC 22-16045. It's a case of Style Maverick Concepts LLC versus Luke Meldrum. Can I get your announcements? We don't have a record, but just tell me who you are and you represent.
Thank you, Judge. This is Chris Brown at K&L Gates in Dallas, and I represent the plaintiff.
Good morning, Your Honor. Jacob Sparks from Spencer Fane, and I represent the defendant, Luke Meldrum.
Okay, and Mr. Brown, I think this is your application for a temporary restraining order, is that correct?
It is, Your Honor. Thank you.
Okay, are you ready to proceed?
I am.
All right, go ahead.
Your Honor, if it pleases the court, I thought a brief bit of background would be helpful. We are seeking a temporary restraining order in this case to enforce a non-compete agreement.
Let me interrupt you just briefly, Mr. Brown. I have read the pleadings, and
Okay.
I'm kind of familiar with the facts. It's okay if you want to recite them briefly, but there's no need to go through them again. I'm kind of familiar with them, okay?
Much appreciated. I thought the background of how Mr. Meldrum came to be dissociated from the company would be helpful, but if you've seen those in the pleadings, I will not belabor that point, and we'll move forward on enforcing the non-compete.
Okay.
So, as a former co-owner and founding member of Maverick, Mr. Meldrum obviously had intimate knowledge, personal knowledge, and familiarity with Maverick's business processes, its intellectual property, its confidential information, its customers, as well as its employees. Maverick's a relatively small to mid-sized company here in Dallas, Garland area with, and I apologize, Your Honor, my colleague on this file, Aurora Barnes, has just joined us.
She's fine.
Just observing. Thank you. They employ about 60 people. They're in the custom design, creative design, and custom fabrication space. They provide, for lack of a better term, large-scale signage and retail displays for retail customers, commercial customers as well, and also do some architectural and construction design and fabrication work out of their location in Garland. Mr. Meldrum is, as I said, a founding member, former co-owner of the company. He was expelled from the company due to some undisclosed and unapproved of expense activity and use of a corporate credit card for personal expenses. Since that time, Maverick has learned that he has gone to work for one of Maverick's competitors, a company in Plano called Pace GFX. Mr. Meldrum, obviously with his extensive knowledge of the company's businesses and dealings and confidential information, is subject to a non-compete agreement. Mr. Meldrum and others at the company have signed this same non-compete agreement. It provides that Mr. Meldrum will not work for a competitor of Maverick for a period of 12 months following the termination of his employment with Maverick for any reason or no reason whatsoever. In that non-compete agreement, he acknowledges certain things about the risks associated with him violating that agreement, including the disclosure of confidential information or going to work for a competitor, and the harm that it would or could cause Maverick. Maverick learned earlier this month that Mr. Meldrum is working at Pace GFX, and I sent a letter on Maverick's behalf to Mr. Sparks advising him of that fact, seeking to have Mr. Meldrum cease his employment in contravention with the non-compete agreement. But since that time, Maverick has learned and confirmed that Mr. Meldrum is apparently still working at Pace, still in contravention of the non-compete agreement. And as a result, we are here seeking temporary restraining order relief to enforce the non-compete agreement, and then obviously the setting of a hearing on 2 weeks' notice with expedited discovery on the relevant issues to have a temporary injunction entered for the duration of the rest of the case, or until the non-compete would expire, whichever would come first, so that Mr. Meldrum is complying with his agreed to obligations under that non-compete agreement. I'm happy to go into further detail. He has made certain acknowledgments in the non-compete agreement that satisfy the requirements for the extraordinary relief that we're seeking today. In fact, he acknowledges that and agrees that the company can enforce this non-compete agreement by seeking temporary or permanent injunctive relief and other equitable relief. So we think the potential harm to him is minimal. Obviously, keeping him from working at a particular place is restrictive, but he's agreed to that restriction as part of his role and duties with Maverick. He's free to take employment somewhere that's not a direct competitor of Maverick. This is not some sort of overly broad restriction. We understand that Mr. Meldrum's skill set extends beyond just providing the types of services that Maverick provides during his time at Maverick. In addition to handling certain operational duties, he was our de facto chief financial officer, or Maverick's chief financial officer. So the restriction in the agreement is not overly restrictive, does not prevent him from gainful employment with someone who's not a Maverick competitor or in some other space. And so we would ask that the court grant the temporary restraining order relief to prevent the violation of the non-compete agreement, which places Maverick's business at risk. I mean, Meldrum is intimately familiar with its customers, its processes, its goodwill, and that's at significant jeopardy by his continued employment at a direct competitor.
Thank you. I have, like I said, I've read the file and I've looked at your application. I've read the letter of this cease and desist. I've looked at the non-compete, so I have kind of familiarized myself with some of the facts that you brought up so far. Mr. Sparks, you have a response?
Yes, Your Honor. Mr. Meldrum was was the founder of Maverick and worked there for 20 years. If you take a look at the non-compete, Your Honor, you'll see that it is dated January 5th of 2022. According to the Covenant Not to Compete Act, a covenant not to compete is enforceable if it is ancillary to or part of an otherwise enforceable agreement at the time the agreement is made. So that's the first restriction. It has to be ancillary to or part of an otherwise enforceable agreement. And the second is that it must contain limitations as to time, geographical area, and scope of activity to be restrained that are reasonable and don't impose a greater restraint than is necessary to protect the goodwill or other business interests. It fails here facially on both counts, Your Honor. First of all, this was entered into in January of 2022 after Meldrum had worked at the company for 20 years. That's not ancillary to or part of an otherwise enforceable agreement. It's the exact opposite of what this provision is intending to prevent. And that's like having somebody, as you're plotting to steal somebody's membership interest and kick them out of the company they founded, having them sign a non-compete and non-solicitation agreement under false pretenses with no consideration of any kind, which is what happened here. So I don't see that this application alleges that there was consideration except for providing confidential information to him before and after. Well, Judge, he already knew all the confidential information. He is the founder of the company. There was no consideration for this agreement. It's facially invalid. Other than that, you have, and definitely have overbroad scopes where you're being asked to enter a temporary restraining order that would make it overbroad through the requested enforcement. Whether Maverick and Pace are direct competitors, I suppose, is a question that we can get to later at a temporary injunction hearing. However, they're asking you to enforce this in a way that restricts him from working in the industry that he has worked in for 20 years. They don't allege that he is doing the same thing at Pace that he did at Maverick because they don't have any idea what he's doing at Pace. But what he did at Maverick and what he did at Pace are not the same job. He is not the Pace CFO, and he is not in a sales position at Pace. He has not solicited any customers or any employees. They don't allege outright that he has. It says in this application that he has communicated with employees about the fact that he has a job. Well, You don't say. Yes, he's communicated with employees of the company that he founded at and worked for 20 years about where he is now. That's true. He hasn't asked any of them to come to work there, and you won't see that pleaded in here because it isn't true. He's not been soliciting customers. He's not been soliciting employees. So you're being asked to enter a TRO that enforces this on an overbroad level by preventing him from even working in the industry. And the enforceability of a covenant not to compete is a question of law, Your Honor, according to the Texas Supreme Court. So based on your reading of this today, you can determine whether or not you believe that this is overbroad. But what granting it gives the plaintiff, and it's really not the plaintiff, it's the person who is now in sole control of the plaintiff by virtue of divesting my client of the membership interest in the company he founded. And what he wants is a litigation advantage. He wants a TRO. He wants to serve it on Mr. Meldrum's new employer, which he knows will probably get him fired because he's now in more trouble than he's worth. It will make, is there somebody that at least his new employer doesn't want to deal with this, as it's a much smaller company. But even if he isn't fired, if he can get a TR, if Mr. McNamara can get a TRO, he knows Mr. Meldrum.
Let's just stick to the facts, Mr. Sparks.
Yes, Your Honor. So if you look at the equities in this case, the equities favor heavily for Mr. Meldrum and against entry of a TRO, because if the non-compete is enforceable, which it isn't, and if he has breached it, which he hasn't, monetary damages are sufficient. In this case, there's no allegation in here that he is doing something for which there would be irreparable damage. But if you look at the harm to Mr. Meldrum compared to, if this is granted, compared to the harm to the plaintiff, I think it clearly falls in Mr. Meldrum's favor. He's an individual. He's working in the industry that he knows. With this TRO, the way that you're asking, what they're asking for, prevents him from even being able to work. Courts around the country and in Texas have roundly rejected the enforcement of non-competes in a way that prevents somebody from being able to even earn a livelihood. And that's what you would have here.
Okay.
Thank you, Your Honor.
Thank you. Mr. Brown, respond to a couple of issues Mr. Sparks has brought up. Initially attacking the validity of this non-compete. Give me some response to the fact that he's saying there was no consideration for the non-compete. It was executed, I think, in January of 2022, and it's overly broad. How would you respond to that?
Sure, Your Honor. On each point, there's direct Texas Supreme Court authority in Maverick's favor, and I'll direct you to that as I go through it.
Okay.
First, the statute does clearly say that non-competes are enforceable and are enforceable by injunctive relief. So the idea that we're not entitled to enforce this via restraining order or injunctive relief because we haven't pled that we can't calculate damages, although we have actually pled it in our papers.
Okay, I understand that, and sorry to interrupt you, but just respond to my questions. I understand
Validity.
that a TRO can be effective to enforce a non-compete. I want you to address the issue of the validity of the non-compete.
So the non-compete is ancillary to an otherwise enforceable agreement, and the non-compete itself contains acknowledgments that establish that ancillary agreement. The agreement is that Mr. Meldrum has access to and would continue to gain access to the company's confidential information, its customer information and lists, and its unique processes and business goodwill. And the case of Marsh USA Inc. versus Cook at 354 Southwest 3rd, 764, a 2011 Texas Supreme Court case.
Okay, repeat that for me again. I'm going to jot that down.
Sure. The reference is 354 Southwest 3rd, 764.
And the style?
Marsh USA Inc. versus Cook. And that's a 2011 Texas Supreme Court case.
Okay.
And in that case, the court expressly held that an agreement was both reasonable and enforceable, despite the fact that the confidential information had passed from the employer to the employee prior to the agreement. So the fact that Mr. Meldrum gained access to Maverick's confidential business information during his 20 years was no object to the enforceability of an agreement entered into after that fact. And
Can you address the issue of the ancillary agreement?
that is what makes it ancillary, that the passage of the confidential information, the business goodwill, et cetera, to the employee is the ancillary agreement. The non-compete is, I agree not to compete for a period of X number of months or years following the termination. The ancillary agreement is that the employer gives the employee the confidential business information, the information that the company has an interest in protecting via the agreement. That's the ancillary to an otherwise enforceable agreement. And Marsh also speaks to that in talking about the fact that the business goodwill was sufficient to satisfy the otherwise enforceable agreement.
What about the consideration issue?
The consideration is the confidential information being provided to the employee, and that has long been Texas law since Light versus Centel Cellular, through the Sheshanoff case, and since Marsh, that the employer giving the confidential information to the employee satisfies the consideration aspect. That's what the company is giving to the employee in exchange for the employee's promise not to then use that confidential information or go compete with the company following his or her time of employment. So this is not, for instance, a case where a company merely promised continued at-will employment. Courts in Texas have held that a promise to continue employment is illusory because Texas is an at-will employment state. So unless you have an employment contract, that's not sufficient. But courts have held that the provision of the confidential information, the business goodwill, access to the clients and customers, is sufficient consideration in exchange for the promise not to compete.
What about the overbroad scope?
Sure, and I've got a couple of cases. Marsh speaks to that. There's also a more recent Dallas Court of Appeals case that speaks to it as well. It's an unpublished case, but it's fairly recent, from 2020, called the Gehrke, Gehrke versus Merritt, Hawkins and Associates. And again, it's unreported, but I've got a Westlaw reference of 2020 WL 400 175. This was a Dallas Court of Appeals case, opinion issued in January of 2020, in which the court talked about the fact that so there's two things at issue in terms of overbreadth. The 12 months, I don't think there's any dispute that that's not overly broad or overly long. This case references, and I think Marsh does as well, that non-competes of 2 to 4 years are customary and enforceable. This one's even shorter. In terms of industry, the non-compete is specific to Maverick's competitors. It's not just anyone in an industry. And we have provided the court with evidence in Mr. McNamara's declaration in support of the TRO application that Pace is a direct competitor of Maverick. And in terms of geographic area, the non-compete agreement is a nationwide agreement not to compete. And the reason for that is stated in the non-compete itself, but I'll elaborate. Maverick's retail customers are nationally recognized brands. I won't go into who they are now, but you would recognize their customers. Their customer contacts are not local. Maverick does not cover a region. Its salespeople don't have regional responsibilities. It services customers nationwide. And so the prohibition is a nationwide prohibition. And the Gehrke case references and discusses these geographic limitations and notes several cases talking about In that case, it was whether the employee, who was a pathologist, I believe, could be prohibited from servicing a larger geographic area than just his immediate area, and I think in the Dallas-Fort Worth area. And the court said yes, because he wasn't just a pathologist at this particular hospital. He was it says let's see here. Broad geographic restrictions have been upheld when the employee held a management or executive position within the employer, and then it cites several cases upholding broad geographic restrictions, including a nationwide and even a worldwide geographic restriction, depending on the type of business that the company was in that was trying to enforce it. And here, Mr. Meldrum, again, was founder, co-owner, de facto CFO. On his LinkedIn page, he describes himself as the director of operations for Maverick during his time there. So he was part of the ownership and management team of the company. And as a result, the United States, the nationwide geographic restriction is reasonable pursuant to Gerke and the authorities referenced in Gerke. So time, I think we've covered geographic limitation, we've covered, and the fact that this is limited to Maverick's competitors, not just an overall industry, I think established that it's certainly enforceable within the scope of the Texas Business and Commerce Code at 1550, I believe.
Okay, Mr. Sparks, I'm going to give you a few minutes to address that response, but before, let me get a couple of answers from you. I understand you are attacking the validity of the non-compete. I understand that. And I want to review these cases that Mr. Brown has cited before I can effectively address that. Let me ask you a couple of questions. Do you agree or disagree that this Pace company is a competitor of the plaintiff? I'm sorry, you're on mute.
My apologies, Your Honor. I actually have that information right here in front of me. My understanding is they are in the same industry. They are not direct competitors providing the same products and services.
Okay. Do they have similar customers?
I think that there may have been some overlap in customers over the years, Your Honor, but again, they use the same equipment for printing. They do not do the same thing with that equipment for the customers.
Okay, can you expound on that for me?
I can. Ooh. Apologize, Your Honor. I got short notice for this while I was at an appointment. So, but here I have it. So, my client says that Pace is a sign shop focusing on the branded environment, logos and office space decorating with wall murals, architectural installations, and vehicle wraps. That is not what Maverick does. So they use the same equipment. They use it for different purposes. Maverick is a creative design and fabrication company. The fabrication relates to different types of printing, like flatbed printing to sheets of material, roll printing to vinyl material, and dye sublimation printing to fabric.
Well, let me ask you this. They're both printing some type of branding. You're saying they're different because of where that branding is applied?
That is part of it, yes. So the equipment at Pace is similar to Mavericks, but they are different brands. And the other types of fabrication that they use after the printing process, or it stands alone, are different. And they're much different in terms of the companies themselves. Maverick has over 50 employees with national accounts. Pace has 15 employees, yearly sales of around $2 million. The one person there is the owner, Mr. Pace. They deal mainly with client referrals. They do not serve the same industry on a national level. They don't provide the same services to their customers.
Okay, take about 5 minutes if you can and address Mr. Brown's response to your issue about the validity of the non-compete based on the consideration, the ancillary agreement, and the fact that you said it was overly broad.
Yes, Your Honor. So the cases that he's talking about, I actually had pulled up and was in the process of reading. These are cases where they said that the providing confidential information could be consideration, even if a contract was illusory at the time it was made. So if at the time the contract is made, it is not enforceable because there's no consideration. So you've got a promise by the employee and no consideration by the employer. Those could become later binding agreements when the confidential information was provided. And then the Texas Supreme Court has expounded on those and said that somebody who has access to confidential information, signs a non-compete, continues getting this access, additional access later, can also have a binding non-compete. What's different here, Judge, is that Mr. Meldrum was the person who at all times already had all confidential information. They didn't give him new confidential. Nobody gave him new confidential information after he signed it. He always had access to the confidential information. He was an officer and founder of the company. These non-competes were intended to prevent people coming in, being taught how to do a process, learning their confidential information, which specifically relates to the materials on which they print, and then keeping them from being able to leave and give that to a competitor. Mr. Meldrum built the company. He already knew all of this. There's no consideration here. It's illusory at the time it's signed, and it remains illusory later. He's got nothing new in return for it at any point in time. And when we talk about the consideration for the non-confidentiality provision, I'm scrolling through here in the non-compete section, looking where it says that he took confidential information. This is about him competing and him speaking to people that he's known for potentially decades after his termination. So as far as the confidential information, what is it? I can't tell here. What is it that they're saying that he took? I know that I've spoken to him. He said, there's no confidential information. There's no solicitation. I've spoken to, I've texted with somebody who is a friend of mine who works at Maverick. I haven't asked him to come work for Pace. I haven't asked anybody to come work for Pace.
Okay, quickly address the overly broad response that Mr. Brown provided.
Yeah, Your Honor, the overbreadth really is a question of law for the court. What I heard there about, these agreements that are 2+ years being enforceable is contrary to everything that I know about enforcing non-competes in the courts in which I practice, and the people in my office that do this full time have told me the same thing. You're looking at 2-year non-competes. These are likely going to be ruled to be overbroad by virtue of the fact that they're 2 years. The trend is away from enforcing these non-competes that go out longer than 12 months. And in this case, if you were to enforce the non-compete and say, okay, you cannot do these things, what you would prevent, and this is, of course, if there's a situation later, Your Honor, where you're blue lining this non-compete, you'd say, okay, well, you can.
Well, let me interrupt you real quickly, Mrs. Sparks. I think we're getting away from the issue. From what I understand, this particular non-compete said he would not accept employment with a competitor for 12 months. Now, just briefly, because of what I'd like to do, I'm going to probably ask for a recess so I can review the case law that you provided to me, but just briefly address the issue. Obviously, you believe 12 months is reasonable and can be valid with a non-compete. Is that correct?
I do think that it could be valid, yes, if he was, if.
I just need the answer to that question. Could be valid. Secondly, is that it says that he's not to accept employment with a competitor, and I think we've got some issues here where you don't think this Pace company is a competitor, and I've heard that response. So let me do this. And let's,
could I give you?
Go ahead. Take about 2 minutes, okay?
One hypothetical. 2 points. First is, if this was an emergency, why did we wait 2 weeks to have a temporary restraining order hearing? I believe that weighs against it. But second of all, Your Honor, so let's say that Pace is a competitor. Does that mean that Mr. Meldrum couldn't be the janitor at Pace because of this non-compete? Because if so, the non-compete's overbroad. And what we don't have is anything pleading in here that he is performing the same position that he was performing at his prior employer. Thank you, Your Honor.
Mr. Brown, last couple of words from you.
Briefly, Your Honor, the standard for a temporary restraining order is a likelihood of success on the merits, which I believe we've demonstrated that we have a valid and enforceable non-compete agreement. We have a former employee with substantial confidential information access working at a competitor. The details of those allegations are to be worked out at a temporary injunction hearing after we've had an opportunity to conduct discovery into the very things that Mr. Sparks is saying we don't have knowledge of. He's right. We don't know what Mr. Meldrum's doing. They haven't responded to my cease and desist letter to say he's not performing those services or performing in a capacity where he would be competing. But that's not the limitation that he agreed to. He agreed not to work for a competitor for a period of 12 months. That's reasonable. It's enforceable. I've got some other cases that I can reference the court to if you're going to take a look at some of those. But I think the statement that a 12-month could be enforceable is sufficient to get me over the likelihood of success hurdle here. So in terms of them being a competitor, again, that's a detail to be hashed out at the temporary injunction hearing, but they provide the same types of services and installations that Maverick does. Everything that he described, wall murals, architectural installations, room decor, all of those are depicted on Maverick's website. Maverick does the exact same thing. They may have different processes for doing that, but they're providing the same types of services to the same types of clients. And the reach of one versus the other doesn't change the fact that they're still doing that. And I think Mr. Sparks acknowledged, and I've been told by my client, and I believe it's reflected in his declaration, that there is customer overlap between these two companies. And we specifically tailored our request for restraining order and injunctive relief to account for the fact that Pace and Maverick have customers in common, and that we're not seeking to restrict Pace's ability to continue to solicit business from its existing customers. So that I just wanted to respond to the whole competitor issue there. But as I said, I think the equities and the merits, or the likelihood of success on the merits supports the issuance of a temporary restraining order here to preserve the status quo until we can have this evidentiary hearing, at which time Your Honor will have the opportunity to make these rulings as a matter of law about the enforceability of the agreement, whether the geographic scope and the time limitations are reasonable. And I would note for Your Honor that the statute actually requires the court to craft more restrictive geographic scope and time limitations and industry scope if needed to make it reasonable. The fact that the agreement exists makes it enforceable, and if otherwise enforceable, the court is mandated to draw those boundaries, if you will, to make it more reasonable if that's necessary. And I would submit that that's not in this case, but that those arguments are certainly not a basis to deny the restraining order relief requested today.
Okay, what's your schedules like for about 2:30 this afternoon? Are you available?
I'm available, Your Honor.
Mr. Sparks?
I have something, Your Honor, but I can reschedule.
Okay, give me until about that time. I want to recess this hearing. I appreciate the efforts that you guys have put into this, and you made some issues very clear. It's just a matter of determining how they should be ruled on. So let's take a recess for about 2.5 hours. If you'll log back in around 2:30, that will give me an opportunity to review some of the case law that's been cited, and we'll be prepared to move from that point forward, okay?
Thank you, Your Honor.
Thank you, Your Honor.
All right, thank you very much. We'll see you guys at 2:30.